Welcome back. You're watching The Firm. 7 global potash manufacturers, allegations of price fixing and a US court judgment. This is a story of the ever-extending reach of USA's antitrust law. Paiswani Upadhyay reports on how a casual connection can give the Justice Department jurisdiction over non-US cartels.
In 2005, Canadian potash company PCS shut 3 of its mines. Shortly thereafter, Minnesota's Mosaic removed 2 lakh tons of potash from the market. In 2006, PCS reduced output from 2.4 to 1.3 million tons. Russia's Uralkali, the 5th largest producer of potash, followed suit. Neighbor Belarus obliged and reduced its potash exports to half. Later in the year, Russia's Sylvaneth took to potash mine stoppages. By now, 500,000 tons of potash was removed from the market. The upset was felt in the United States, the second largest importer of potash, where prices shot up by 600% between 2003 to 2008. With all these allegations in hand, US potash importers filed a class action complaint accusing these global producers of price fixing. They alleged that these companies inflated potash prices in Brazil, India and China and benchmarked the foreign prices for sales in United States, conduct that violates the country's antitrust laws. The accused, hoping to get the case dismissed, simply argued that US laws didn't apply to them.
Well, their argument was that we, the defendants, are potash producers who operate outside of the United States. We are headquartered outside of the United States, and the claim is that we participated in a cartel outside of the United States. And so the argument by the potash producers was that the antitrust laws under the FTAIA simply do not apply to them because the effect of whatever they've engaged in does not have a direct impact in the United States.
This Foreign Trade Antitrust Improvements Act, or FTAIA, that Wesley just mentioned became the crux of the Minchem or potash case. Implemented in 1982, the FTAIA limits enforcement of the country's primary antitrust law, the Sherman Act, in situations where there is no direct impact of cartel behavior on US consumers.
The FTAIA was enacted in the early 1980s, and the reason was that there were an increasing number of lawsuits brought in the United States challenging alleged antitrust conspiracies or cartels around the world, some of which, frankly, did not have a real material impact on the U.S. economy. People were just coming into court in the United States because they thought it was a favorable place to bring a lawsuit. And there was a concern that allowing the U.S. essentially to enforce the antitrust laws all over the world wasn't really respecting the jurisdiction of other countries.
And it's this jurisdictional limitation set by the FTAIA on the Sherman Act that came to test in the Minchem case. The court ruled that FTAIA does not impose a jurisdictional limitation on the US antitrust laws, and that Sherman Act would apply if there is a reasonably proximate causal nexus between the foreign activity and the effect on US commerce, a view divergent from the established case law.
I guess what's unique about it is that this particular circuit was not shy and sort of not caught up in the idea that there was foreign conduct in foreign countries and didn't stop there as a very simplistic analysis, but took the sort of next step to say, yes, of course that's what some of this conduct was, but it obviously had an intended and foreseeable effect in the United States. And so it's this sort of second layer of economic thinking, which is frankly sort of economics 101 in some ways.
The decision is a departure from many other decisions that have reached a different result. Essentially in any case where the question is, does the FTAIA apply, and can the antitrust laws the U.S. antitrust laws be enforced? The court has to answer the question of, did this conduct that happened abroad have a direct, foreseeable, and substantial impact in the United States? So courts have routinely passed on this issue, but most courts had found that direct really does mean direct. It means that the foreign companies did something which had an immediate and direct effect in the United States. This court found that stringent test didn't apply.
In doing so, the 7th Circuit Court of Appeals may have expanded the applicability of USA's antitrust laws.
Where I think this might give some foreign commerce some pause and some foreign firms some pause is that there isn't this bright line test where your conduct is sort of directly linked to your import commerce in the United States. It may still be possible here, where they were sort of price fixing allegedly for other countries, as long as the effect is direct and foreseeable, or rather foreseeable and intended, you can still be caught under U.S. law. And so I think that companies who know that their goods are intended for U.S. consumers need to be wary of these facts.
If courts follow this case, it will not be decided right away as a jurisdictional question. The decision will come later in the case when the court's considering the merits of the actual claims. That has a very bottom line impact in that it will cost those companies quite a lot more money.
Not only money, but time as well. Both the experts in this story also pointed out to me that the bench of the 7th Circuit who gave this judgment comprises of 2 leading antitrust scholars, and there's a good chance that other US courts may also hold the same view in subsequent cases. That means the jurisdictional limitation defense may no longer hold good. In Mumbai, Paiswini Upadhyay.
All right, with that, I'm going to wrap up this edition of The Firm. Thanks for watching. And a quick reminder that this week, The Firm speaks to SEBI Chairman UK Sinha. Don't miss that special edition at these times on CNBC TV18.